My name is Reid, and I'm the chair of the Compliance Officers Forum. The Compliance Officers Forum has been meeting for the last 14 years, the third Wednesday of every month at 1:30 Central Standard Time. The forum consists of compliance professionals, legal counsel, industry leaders, company leaders, and anybody else who's interested in keeping up to date on the compliance and regulatory issues facing our industry. Every PACE member is welcome to join the calls. You can log into the PACE website and get more information about the Compliance Officers Forum calls, and also to register to join those calls. We'll send you out a link and a passcode to join those. It's open mic, so everybody has the opportunity to share their thoughts, comments, and if you have an interest in speaking or presenting information on the forum, please get a hold of me. I'd be happy to let you join and speak on one of those calls at your convenience. So with that, I'd like to introduce our panel. And first, I'll just move right down the line and in succinct order here. First, Nick Whisler, who is a partner at McMurray and Shuster. He focuses his practice on helping clients understand and comply with federal and state telemarketing, advertising, privacy, and other consumer protection laws. Nick works with a wide range of businesses, from startups to Fortune 500s, to identify and mitigate regulatory risks. He includes the creation and implementation of compliance programs and conducting regulatory audits and resolving complex compliance issues. Next to Nick is Michelle, who needs no introduction, so I won't. And then finally, Rebekah Johnson. Rebekah is the president and owner of Gloria-Mac. Prior to launching her company, she worked for regulatory affairs with West Corporation. She also served on the FCC's Robo Strike Force, supporting an empowering consumer choice work group. Her efforts continue in her role as a coalition leader with PACE. And so I'd like to welcome our panel today. So if you give them a warm welcome, we'll be starting.
So real quick for an agenda for the day, we're going to talk a little bit about some of the stuff going on at the state level. Not nearly as much, fortunately, there, but we will talk about some will probably be touched on throughout outbound telemarketing calls to disclose that the call is being recorded. So New York is generally a one-party state, so under their wiretapping, eavesdropping laws, you only have to disclose, we're going to get consent from one party, probably your agent. If you're going to record calls, it now requires two parties for at least outbound telemarketing calls. Indiana had proposed over the years several different versions of this law, but basically they're trying to make it specific in the statute that a seller can be held liable for calls made by its agents. So if you look at it, it's fairly similar to what you would see under common law principles of agency, but it's built right into their statute now. They also adopted a requirement that you disclose the name of the telemarketing entity that is calling in addition to the seller. So at the federal level, you're allowed to just use the name of the seller. In Indiana, when calling in Indiana, you would now have to disclose the vendor name and then the seller name as well. Florida updated its do not call law such that when a consumer puts his or her number on the list, that number stays on there permanently. I believe it's 5 years before it would be removed, so that's no longer the case. A couple caller ID laws, one in Tennessee, one in Vermont. They're different, but they both are that is sending false or misleading caller ID information with the intent to defraud, cause harm, etc. And then the Vermont one is just an active requirement for telemarketers to transmit their phone number and, if possible, their name when making outbound calls. So pretty minor changes, nothing too significant there since you're already required to do that at the federal level. And then the Oregon one was just a little bit interesting. They have established a task force to address what they're calling anonymous text message services. So it's, I guess, a little bit similar to the caller ID spoofing issue, but it relates to texts, and said no actual laws or regulations there, but they have established this task force, so something to watch moving forward. Just a couple other kind of updates at the state level. One was a case involving Quicken Loans. And for those of you that are probably familiar, California has a very onerous call recording law, and it provides a private right of action and up to, I think it's $5,000 per violation in damages. And so this particular fact pattern was the person had called in, they had provided a disclosure that the call was being recorded, they had previously disclosed that in their customer agreement, they had it in emails, so they had all these different sources where they're informing their customers that calls were recorded. They got disconnected during a call, they called back, and during that callback they did not make the disclosure. And what the court said was that the consumer, the plaintiff, was on notice that they were recording calls, and therefore there was no violation. So big takeaway, get consent wherever you can, throw it in your customer agreements. I've seen people even put it on lead forms. I've seen companies obviously use IVRs for non-calls, so it's kind of a fallback in case you have an agent error during one call. And then, actually going back, we got lots of questions recently regarding state rules for calling during a state of emergency. So for everything going on in Texas, everything going on in Florida, lots of questions around this. What I can tell you, and you may have received an email from PACE about this, is that Louisiana is the only state that has an actual specific prohibition against calling during a state of emergency. When we get asked the question, we typically say, use your best judgment. What type of an issue is it? What type of a call is it? A cold call may be different, for example, than calling one of your existing customers that had some type of a customer service issue. So use your best judgment, but Louisiana is the only one with a specific prohibition against that. So with that, I'm going to turn it over to Michelle to do a few of the federal updates.
Well, so my updates could be really quick because basically Lois Greisman stole every issue that I was going to talk about during our updates. She did a really great job of discussing what the FTC has been up to as it relates to our industry. One thing that she didn't mention, though, was the fact that the cost for the Do Not Call registry went up. It was a slight increase. It was $1 per area code. So we're now seeing an increase in cost around $300 to $400 for purchasing all area codes in the United States. On the call blocking front, Rebekah is going to spend a lot of time talking about that. Lois talked about it. It's obviously the hot topic right now. As Lois said, the FTC weighed in on this issue when the FCC released a notice of proposed rulemaking. And as you could tell by the glee in her voice when she was describing it, the FTC is all for call labeling and blocking. And they will have a representative at the Call Protection Coalition meeting that we have scheduled for Wednesday. So obviously a very hot topic for the FTC. Also related to that, as Lois mentioned, the FTC is releasing on a weekly basis numbers that were received in consumer complaints. It is just really important to understand that those consumer complaints have not been verified. She said it, kind of glossed over it, but the fact of the matter is people could just be calling to say, they wanted to get a call about a white refrigerator and they got a call about a red refrigerator or something like that. There is no violation of the law that is verified on these consumer complaint telephone numbers of calling parties that have been released. Yet, those numbers are now being used, I'm hearing anecdotally, as putting our vendors, our third-party suppliers on notice that they have an issue because their phone numbers are being recorded through the FTC. And I'm hearing about people that are having to answer questions now to their carriers about numbers that are being released from the FTC. So this is an issue we're all going to start dealing with. I would like to hear about those types of things. Obviously, that's an important perspective that we as an association need to take to the regulators. So Rebekah and I would, and all of us on the PACE administration board would like to hear about those types of things. Soundboard litigation, I know Art Combs is here. Art, you want to wave? Lois also talked about the soundboard technology appeal that is currently going on. PACE was involved, it has been involved in that process. One of the outcomes of our meeting here last year was that after Lois left the next day, she and Janice sent a letter to us saying that they were going to revoke their previous position on soundboard technology not being a pre-recorded message. I will tell you, my concern all along has been, even beyond what's in that letter is just the implication of the interpretation that a call including a pre-recorded message is a violation of the TSR. I suspect many of us in this room use pre-recorded verification scripts in some of the sales that we do for very good reasons. It complies with, we can ensure that our agents haven't missed any of the disclosures that are required for payment authorization or in order to make all the materials disclosures prior to making a sale. Yet, in the way that they have interpreted, pursuant to their soundboard letter, that type of call would be a call that included a pre-recorded message and violated the TSR. I have had conversations with the FTC, and they have said that they understand the just the inherent importance of making those disclosures and see how pre-recorded messages are good for making those disclosures, and that they would use their prosecutorial discretion to not bring cases for people that are using pre-recorded messages in their validation scripts. Well, that is all well and good. No one in this room wants to violate the law. So I throw that out there so that you can have a conversation with your legal counsel about those types of issues if you're using pre-recorded verification scripts. Also, the soundboard technology appeal is still ongoing. Art and Soundboard Association are doing a good job of continuing to pursue that through the DC Circuit Court. There we go. Thank you. Nick, you are now in charge of that. You're in charge of the technology, that's right. So we have a whole session that starts, for those of you that will stay to the last session today on the Dish Network case, it is sure to be the highlight of the day, but it is a really important issue that we're talking about, and that's vicarious liability. Dish Network had the largest penalty, civil penalty, ever imposed by the FTC, or for, I guess I should say, for violation of the FTC Act. Imposed against them with a $280 million judgment. And it was actually more than that because there was a class action lawsuit that was decided shortly before this case that ended up with the court trebling the damages in that case. So all in all, Dish Network is looking at somewhere around $340 million in penalties for what the courts have said is their failure to control their agents. And we're going to go into a lot of detail about what that means, how your vendors can become agents, and how you can be responsible for their activities through a theory of vicarious liability. So it's an important topic that we'll be discussing. And the FTC obviously feels very strongly about this, but it goes beyond the FTC. The case also involved violations of the TCPA. There were 4 states that joined the FTC, and they were pursuing TCPA violations, and so that's where we talk about agency, and on the FTC side, it's more about accomplice liability, assisting and facilitating. So stay tuned for that presentation this afternoon. As Lois also said, they are actively enforcing cases against robocallers, and I hate that term because I don't think it really defines anything. As you've heard today, there are 20 different definitions for what people think a robocaller is, but specifically what I'm talking about is cases against companies that are using pre-recorded messages. And the FTC is going after the companies, but they are also going after the platform providers if they were accomplices in making those types of telephone calls. It started with a case against Callfire about 2 or 3 years ago, and the FTC's assertion there was Callfire must have known that calls were being made unlawfully because of just the sheer volume of calls that were being made using their software, and as a result of complaints that they were getting. So they are actively pursuing that area. Also, as Lois said, the new commissioner the acting commissioner, I should say, has announced that they will be streamlining their CID process and providing more transparency. I know there are a few folks that have gotten CIDs, regardless of whether they were involved. It could be as a result of persons that they were, or companies they were doing business with, but it's a pretty terrifying document to receive because you have no idea why you received it in its current state, and the amount of information that's asked for would shut most companies down for a month in providing, and most of it not relevant to the types of investigations. So the FTC has recognized that. The acting commissioner is calling for more transparency and more information being given to to companies that receive CIDs. It's very important, and Lois mentioned this today. If you ever do get a CID, the first thing that really needs to happen is communication with the FTC attorney that issued that CID so that you can start negotiating what a response looks like to the CID. The CFPB is a very interesting regulatory agency right now. They have been coming under fire by Congress, members of Congress, and a number of industry associations and other organizations. The current director, Rich Cordray, I think his term expires mid next year, but it doesn't matter because he's going to come run in Ohio for governor. So he may be the governor of our state, depending upon how things go. But one of the things that they have done, and that was as a result of a mandate by Congress to look at arbitration rules. And they have announced for companies for which they have jurisdiction over, which would be financial services industries, including credit card companies and payment processors, wow, we're awake now, that I'm sure all of you are using, that the mandatory arbitration clauses that are contained in those types of agreements can no longer have class action waivers in them. Additionally, you have to affirmatively disclose in the arbitration agreement that the consumer is not waiving their right to bring some type of class action or class action arbitration. There's also certain filing requirements if you are going to go through the arbitration process with your consumers to file your arbitration clauses and certain actions that happen during arbitration with the CFPB. The effective date of that is 3/19/18. The House has already passed a bill that would block the implementation of this arbitration rule. The bill is now pending in the Senate. Last updates I saw is that it wouldn't be considered until members of Congress returned from recess, and I haven't heard that it's being considered yet. So stay tuned on the CFPB mandatory arbitration rules update.
So shifting gears a little bit, back to the TCPA or race fair topic. We have several kind of subtopics to just provide updates on. The first being the definition of ATDS. I think what I would lead with is we're seeing less case law interpreting the definition, simply because many cases right now are being stayed pending the result of the DC appeal that base file. So we have seen some cases come in. Most of them have been fairly favorable. And when I say fairly favorable, I mean not that a predictive dialer is not an ATDS, but that a click-to-call system, systems that actually require human intervention are still being found to fall outside that definition. So some courts seemingly only look at the human intervention aspect. Some give the FCC's potential capacity standard its deference, but nonetheless, when they go back to the analysis, that they revert to human intervention. So quite interesting. We get asked a lot whether human intervention must be 10-digit dialing versus click-to-dial. I think there is a overwhelming amount of case law supporting the concept of click-to-dial, so long as you don't have the other underlying auto-dialing capacities. We're starting to see some opinions talk about companies that either have two systems or maybe use a cloud-based system, and they're differentiating between a call being made by one versus the fact that the company has another system, a predictive dialer most likely, and they're looking at things like the use of different hardware, the use of different software, things like logins potentially could be relevant. So distinguishing between one system that's used to call cell phones without consent versus another maybe that's used to call landlines or call numbers with cell phone numbers with consent, something that we're starting to see in the courts. Text message platforms, we're still seeing some of those cases. We had noticed a slightly favorable trend on the type of systems that you might expect to see in the industry. So you're selecting the numbers or uploading the numbers that you would like to receive a text. You're typing out the message or maybe selecting from a pre-canned list of messages, and then you're either clicking a button to send them all or to schedule them for some future time. There had been a few different courts, one from the Northern District of Illinois, one from the Northern District of Georgia, that had held that they involved enough human intervention to fall outside the definition of an ATDS. I will caution you, though, that the Seventh Circuit recently overturned one of those opinions, stating that while there was a lot of human intervention involved, it didn't involve human intervention at the precise time the texts were being sent. It didn't definitively rule that the system was an auto-dialer, but it said that the grant of summary judgment, or maybe it was motion to dismiss, I can't recall, but that it was too premature, and so that was something that that shouldn't have been ruled on at that time. So kind of the things that I always look at when I'm looking at and evaluating text systems are the ability to kind of schedule batches for future delivery. Some courts may have some issues with that, and also the ability to auto-respond to an inbound text. There's been some cases that said that that's okay, it's still human intervention. The user is sending a text in, the system is just kicking a text back out, but some courts wouldn't dismiss the case simply because they said that that was a question of fact and a jury would have to decide that. So those are the kind of two big things to think about if you're using a text platform and trying to evaluate whether you need consent. Written consent, still not a ton of case law out there. We saw one prominent case, the Sullivan case, related to online lead forms, which are typical online lead gen form, except for you're providing information at the top, including your phone number. There's a submit button, and then somewhere below that button was some consent language. The court said that the disclosures were not clear and conspicuous, therefore the consent was not valid, and they said that the overall impression of the form gave them no notice that if they filled it out, they would be called, other than the fact, I guess, that they were protecting their phone number. But nonetheless, I think a lot of people are interpreting this opinion as saying you can never have language below the submit button. We always recommend, of course, that you make it as conspicuous as possible, putting it above the button. It seemed, though, in this particular case, it was well below the button, so it's possible, although I can't state with certainty, but it's possible they may have come up with a different decision had it been, large letters right below the submit button. But nonetheless, some guidance there. We often always get asked about, can I get consent in my customer contract? And we've always taken a pretty cautious approach there. The concerns are that you're requiring somebody to provide consent, which is prohibited under the TCPA, and also maybe courts taking issue with the conspicuousness of that language. There is some case law out there upholding that type of thing. The one here mentioned was a case involving Acura dealers, and they had consent language in at least some of their lease agreements. And the court said that that was conspicuous enough in that particular context, and they did not take issue with the fact that it was part of the transaction, because they said that they would still, there's some language in there basically indicating that they would still go through with the transaction if they objected to that. So what I would say as a takeaway, I still am reluctant to rely exclusively on a contract provision, but it may be wise to think about whether you should add language like that to your customer contracts as a backup argument in case you run into some type of an issue. The other scenario we're seeing when they're talking about written consent, whether it's valid, relates to inbound texts. So you see a call to action, text this message to this number to opt into this program. A couple different cases, the one involving polls, they found that inbound text in response to a call to action that had good disclosures was valid written consent. The other case, this Larson case, the court actually said that that was not valid consent. They took issue with the lack of an electronic signature, or lack of a signature to begin with, I guess, and that they didn't have a required disclosures. So I personally still think that if you have it set up the proper way, you have really good consent arguments. And I think that may have been more of a issue with the facts and the fact that they didn't have the required disclosures on the front end. Maybe the result would have been different. Revocation of consent. One of the things that we had seen the plaintiff's attorneys get really aggressive on and really try to set companies up with was, instead of responding text or stop to a text, they would say, "I'm no longer interested, take me off your list," like some run-on sentence that the system didn't recognize, and therefore they wouldn't opt them out. They were alleging that that was a violation because they had revoked consent, and every text after that was a violation. We've seen at least one court now say you try to revoke consent in a non-compliant manner. In this particular case, it was a little bit different. They actually went into the store to try to revoke consent, but in their opinion, the court said all you had to do was text stop. Those were the instructions. Those were part of the agreed terms of the program. You didn't do that, therefore you didn't revoke consent. So it's pretty good for those engaged in text community campaigns. You've got this Ninth Circuit opinion, the Schweitzer case, saying that you can partially revoke consent. So that was somebody asking not to be called. I think it was a collection call, but asking not to be called during the day or at work. And the court said that you can partially revoke consent, meaning that you would have to honor that kind of partial request.
Just when you think it can't get more complicated, right? Training systems are set up to honor that type of do not contact request, right?
Yep.
Collector.
So the other ones we've seen was the Second Circuit saying that you couldn't revoke consent from a bilateral contract. Again, it distinguished other courts that said that consent was revocable under the TCPA on the grounds that those were kind of gratuitous consent versus consent obtained through a contract. So all still kind of developing there. Would just be cognizant of those opinions, and as the DC rules on the FCC 2015 rule, and that may also impact it. We have a whole other session on vicarious liability that's been talked about several times already, so I will, in the interest of time, just skip through that and get to the.
He's coming back to talk about those at 4.
Real quick, this is worth mentioning. Probably not very many of you still doing faxing. The only reason that this slide here is relevant for most of you is the fact that the Sixth Circuit, so a little bit of quick background, the DC Circuit recently invalidated a prior FCC order related to faxes. And the Sixth Circuit just said that that was binding outside of the DC Circuit because it was the exclusive or sole forum for challenging that FCC order. So I bring this up only because it is really good precedent if the DC Circuit rules in our favor in the PACE appeal, as we like to refer to it as. That is going to be good precedent to say, okay, the fact that the DC Circuit invalidated that FCC order, that's binding in all circuits, not just the DC Circuit. So it's really more procedural in nature, but very important. Sure.
This is the current makeup of the FCC. The most important item up there is that we now have Chairman Pai as the chairman of the FCC. He has had some very common sense opinions in the declaratory rulings that have been released, so we see that largely as a very positive thing. PACE will be meeting with his office and with the FCC on a number of different issues over the course of the rest of the year. The one thing, though, that you do have to be careful for is you've got to be careful what you ask for. So when we were filing some of our comments and requests for declaratory ruling, one of the things that we would point out was the lack of enforcement by the FCC, and that if they were looking for a way to deal with the issue of robo or illegal calls, then it should be through enforcement. Well, since Chairman Pai has been in office, they have significantly ramped up their enforcement efforts. And that was something that he had pointed to in the 2015 declaratory ruling, that he thought that the FCC should become more aggressive, and so they have, and these were largely against robocall. I'm falling into using that. Pre-recorded message calls, illegal pre-recorded message calls that were made, and some of these against platform providers. Talking about the appeal is very quick. There is no update. We had reserved a spot here in hopes that we would have a decision by now. I think I have been saying that I thought we'd have a decision by spring of 2017. Obviously, that didn't happen. But there are so many cases that are currently stayed. When the opinion comes out, there is going to be a significant increase in activity in the federal courts. So stay tuned. PACE has been very active in filing petitions and notices around, or comments around a number of different issues that are currently pending with the FCC. The list is up there. All of these comments and all of these documents are on the PACE website. So if you're interested in seeing what the position for PACE has been, feel free to download those. You can also let me know, and I'm happy to send them to you. But I ask that you pay attention to the newsletter that comes out every Tuesday from PACE. As we receive notices that the FCC or any regulatory agency is requesting comments or is filing a notice of proposed rulemaking or any of those types of things, the first thing we do is solicit your input, because that's really what's the most valuable thing. You guys are the industry experts, and we take that information that you give us and we put these into the various documents that we file with the regulators. So it's really important, and I would ask that you continue to pay attention to those types of requests and help us out. And with that, Rebekah, it goes to you. You're probably capable of using the button.
Yeah. So I know everybody wants to hear more about robocall blocking and labeling. My God, what more did she say? I'm not going to say anything, but I've got pictures, so we can applaud for that. Finally, you're going to get some visuals of what's really happening. So real quick on who I am, I had some experience on the robocall strike force, so I was on the empowering consumer choice. And well, by God, we are empowering consumer choice, aren't we? So let's just get right into it. This is just a lot of words on a slide. I don't expect you to read them. So what I've done is highlighted the most important part. This came out of our report that we filed in October from the strike force, and that right there is a diverse multitude of evolving mitigation tools and efforts. And you even heard it again today from Ms. Lewis with regards to, you know, the FTC has released the complaints, therefore they want innovation. And if you've watched any of my videos, I don't love innovation that much. Not in this space, particularly because, hey, the carriers are regulated. I think you guys are regulated, otherwise why are we here? So I don't understand why we would encourage unregulated innovation right in the middle of the two industries. So I think what you're going to see with the coalition is it's not as cowboy as it really is. We can get some ropes around this and get some kind of order and expectations between what's happening and the initiatives of the carriers, what they had to do. I mean, part of the strike force was we did have to answer the requests of consumers to do something about these calls. I mean, everybody here gets the calls. So it just needs to get a little bit more clarity. I do want to point out the industries that can carry on the torch of the strike force. Obviously, the strike force was comprised of everybody that sits in those same groups. So they've already been kind of working on these initiatives. That's where Stir Shaken is coming from the Addis group under the leadership of Richard Shockey. And everybody's been involved, at least on the telecom side, to develop that framework in which we can get some authentication. But I'll cover a lot more tomorrow, that it's more than just that. The framework is valuable, but there's a lot more activities that are going to happen. So to the pictures we shall go. Hey, there's your first one. All right, so this is the 30,000 foot level of what the heck just happened this year. So we've got the carriers. Obviously, there's more than that. We have the MVNOs who are going to be involved, and I just can't put spots for them everywhere on these slides. But you've got these, what I refer to as analytics companies. Oddly enough, that term seems to stick. So I think I actually labeled the whole industry. Kind of fun. So I just refer to them as analytics. They're the ones who are running those algorithms and developing the call blocking capabilities and also the labeling. So they each have their own secret sauce, as they should, because we encourage competition here. So they're going to maintain how they approach it. And then they each have their customers. Well, AT&T sees their subscribers as their customers. So does Verizon, so does Sprint, so does T-Mobile. Except those are your customers as well, right? And so now you've got this additional layer that's between you and your customer. And the thing is that they can kind of touch it. They can touch your calls, do something with your calls, unbeknownst to you. And that's where the big problem comes in. I don't think anybody here is against stopping the fraudulent calls. I will say one of the things that shocked me when I was in DC for the kickoff of the robocall strike force, I got an invitation to participate, and it was all about fraudulent calls. Get there, we're sitting there, and Chairman Whisler begins his speech. Well, he goes off on a tangent, and he starts talking about these unwanted calls. I'm like, whoa, what's that? Wait, unwanted? Who says unwanted? You know, who's defining unwanted? And I mean, all of our heads just started turning, going, this isn't what the invitation was about. And that sort of became really clear that they're going to empower the consumer to make some decisions with regards to the calls that are delivered to them. Legal or not, they're going to empower them. So that's what you guys are starting to experience now. So one of the main issues is that we don't have visibility. And the coalition is focused on getting that visibility, working with the carriers, working with these analytics companies, and guess what? Everybody's showing up. So we got everybody to come to the party. We are going to try to figure out how we can all work together. I encourage you to stay in touch with that, voice your opinion. Even if you're not on the coalition, your opinion still matters, we need it. And the carriers and analytics companies are here because they want to hear. They do want to hear from you. How is this impacting? So I wish that Ms. Lewis was still here because I would totally answer her question on what? Labeling? Are you kidding me? These are from my phone. The nuisance likely, telemarketing, and informational. Tomorrow I want to go into the story of what was the call behind those numbers. Very interesting. And yes, I have reached out to the analytics companies that offer that labeling, and we have reconciled some of those. So, but that's what it looks like. Who here has gotten those labels? Yeah. Has anybody answered them? I answer every single one because I'm just fascinated with it. But anybody answered them? Okay. Was it truly what it said it was on the other end?
No. It was an invited call from a company that was, I had a client with a customer relationship with. Reason, and it's ironic you mentioned, I'll just sidebar real quick. The reason that I took the call was because that same client had sent me a screenshot of that a litigant had just filed a case against them. The litigant had asked this customer of theirs, asked them to call them. They called them. The app branded them as scam likely. The litigant then was contacted by, the plaintiff rather, was contacted by a litigating attorney who then filed a class action against the company for an illegal robocall, even though the person was a customer and had asked them to call them. Because the caller ID was blocked and replaced with the label scam likely, it went right into the class action instead of its bucket. $25,000 later, we finally got them to go, oops.
Yeah.
That's what it cost us.
Yeah.
To straighten that out.
And some of them think it's Mr. Scam likely. Who's Mr. Scam? They don't even know. Consumers, this is new to them too. They're not even sure what this even means. What that kind of goes back to, and thank you for sharing that, is the education around this happening. Who else feels like it just kind of happened? Like nobody really cared that you had, this was going to affect you. That was why I kind of jumped on this and started raising awareness around it, because the carriers didn't do a good job of letting everyone know that this was happening. And I love the carriers; they all love me. But I had a real big problem with the fact that it was obvious they're really not aware of how you guys even deliver calls. Like every example, I sat on CTIA as well. I'm no longer on it because I kind of changed my position. But the example they would always use is just like a doctor's office. I think they thought the only ones who delivered phone calls were the dentists. Seriously. I mean, it was just like, that's your only example. What about the bank? What about the debt collectors? How about utility? How about education? And that is actually kind of new to them from the perspective of the regulatory side. So they are aware of that, which is why they will be represented on Wednesday during the coalition to hear what we have to say. And for those who are coming, speak up, speak up, speak up, give your examples, let them know your perspective. I will say I'm not in agreement with everybody's perspective on this issue, and that is perfectly fine. But I think we are all in agreement that something needs to be done about this. We need to continue the legal wanted calls, and I really believe that PACE is the association to lead that charge. I don't know if you guys realize you're leading this charge not just for the typical companies who are in this association, but also for healthcare, the utility, and the education side, because even they're not fully aware that this is happening, and they'll be just as impacted as you are. Did I get that right? Is that a better version? I hope it's a little bit more lively. Any questions?
Yes, I'd like to open it up for questions now, but if you ask a question, please direct it to the individual that you'd like to ask a question of. So, anyone have any questions? Yes, right here in front.
So this is for anyone.
We've got a mic coming for you.
Just curious, are there definitions in place for each one of those currently?
Okay, so yeah. You're going to see that tomorrow in my presentation. So I just feel like I'm really bad. I was part of that. So I defined, I was part of the group that defined these call categories, but informational is up there because I fought for informational. Yes, I'll give you the full definition of all of them. Does not mean that that's how the carriers will implement it. does not mean that that is the only list that they can show. So they have the right to be able to show other things as well. And little, behind the scenes curtain view of this as well. I saw the biggest challenge, and I actually took this whole conversation offline with the strike force because there was only like 5 people who would get involved in it, and everybody else was quiet. So I said, that's it, I'm gonna go to this group, we'll define it. And they kept going round and round and round on entity versus intent. And I tried desperately for them to get clarity on that. So you're gonna see a combination of the entity as in debt collector, that would be entity. And then intent would be telemarketing call. And so I think there's still confusion, and this is where PACE can bring that clarity. I'd like to bring that topic back up with this group. Because being in the healthcare side, I would always say, well, okay, a healthcare call can actually be telemarketing. Immunizations are telemarketing calls, by the letter of the law, they are. Now, there's some exemptions for them, but are you gonna label them telemarketing? Now I've got CDC issues that I gotta deal with over here. And now we're talking about the health population. So how those labels get used is where PACE can help drive that as well. I believe there's lots of conversation and discussion around that. So, but you'll see the definitions tomorrow, and I think you'll get a copy of this.
Other questions?
Thank you. Rebekah, when did labeling begin?
Where are we?
When did it begin?
Now, this labeling,
Yes.
this is live and active, yeah. It's just a matter of adding additional labels.
But when did it start?
Oh, when did it start? I think we're looking at around March time period, probably when we started feeling it.
Thank you.
Other questions?
Michelle, what is or maybe PACE doesn't have a position yet as far as the argument of constitutional argument as it being a restriction on commercial speech?
So right now, we're looking at many different arguments and even many different paths on this issue. As you heard Jim Noble talk about before our presentation, shaken and stir is something that we're very interested in, and we think that that is a better solution than arbitrary labels. I mean, we all know in this room the definition of telemarketing, if that's what you're listening is not something that we even all agreed on or that the regulators agreed on. So having an analytics company try to label calls in that way is a very difficult thing. So yes, we're considering that. Ray Pollum has some very interesting ideas around the caller ID laws and how those could be violated by what's happening. Obviously, constitutional arguments are some of the first things that came to mind. And right now, what we are trying to do and what Rebekah is assisting us with is really defining the problem, understanding the problem, getting all the players in the same room at the same table to discuss this, including the regulators, so that we can formulate the best response. So Wednesday is the start, and we'll be having a lot of discussions like that, Rich. And we'll be calling on a lot of the attorneys within the association, I suspect, too, to help with that. So thanks for volunteering, Rich. You now have the constitutional argument.
We have time for one more question, so.
Thank you. Can you hear me? Okay. I apologize if I get this wrong, Nick. I think you were the one who brought up this topic about the segregation.